Yes, Mr. Liquidopoulos.
Good morning, my lords. Good morning, my lady. You will have seen that I appear with Mr. Gamza for the appellant,
Yes.
NOCO, my learned friend, Mr. Cuddigan, KC, and Mr. Cronin for Carku, the respondent.
Yes. Well, I can tell you we've read the judgment, we've read the skeleton arguments, and we've looked at the authorities.
Thank you, my lord, for that indication. In that case, you would have seen that the appeal concerns the threats provisions of the Patents Act 1977, as amended, and a series of communications made by my clients in 2020 using what's called the Amazon IPR policy and procedure, which Amazon encourages rights owners to use. And under that policy, right owners can complain about potential IPR infringements on the Amazon website, not just brands and counterfeits, but also other IPR rights, including patents. And Amazon says it will then consider those complaints and can action them by delisting products from the website. That occurred in the present case. In the present case, both parties used the procedure to delist each other's products. And Carku say that my client's use of that procedure amounted to unjustified threats of patent infringement proceedings and caused them loss. Now, there is a flavour in my learned friend's submissions on this appeal that it's about the way in which threats provisions should be applied to an online environment. And he cites cases about how legislation should be purposely construed to keep up with technological advances. And he goes as far as to say in his skeleton at the opening that our case is that the threats legislation does not cover notifications to online retail platforms. Now, that is not our case. I should make that clear from the outset. Our case is...
communications would either be or not be a threat, even if they were delivered by post.
Exactly right. And we accept that. And we're not suggesting that somehow that an online environment has different rules or a different approach. Neither, we say, is this a case about whether or not the Amazon IPR policy is fair or not. It may well be that Carku do not approve or do not like the way Amazon goes about policing its website. But again, that is not in our submission before my lords and my lady today. Our objection in what the judge did is in any form of repurposing of the threats provisions, if you like, to assist those who do not approve of the Amazon policies or think they are fair. We say what one has to consider, and the only issue before my lords and my lady today, is whether the communications that my clients sent would, in all the circumstances, have been understood by a reasonable person in Amazon's position as being threats of patent infringement proceedings, either as against Amazon itself or against the third-party sellers of Carku's products. Now, you will have seen, of course, and that's why we're here, that the judge held that the communications were threats, would be understood as threats of patent infringement proceedings, both as against Amazon and the distributors. And he gave permission to appeal, primarily on the basis that this is an appeal which concerns the interpretation of documents.
If he were wrong about threats against Amazon, it wouldn't matter if he was right about threats against third parties, would it?
It might matter in the sense of injunction, I suppose, my lord, because he issued an injunction, and if he was right about threats to third parties, potentially, I suppose, that could then still be an actionable threat, and therefore it could still matter.
Why would that make a difference to the injunction? I assume it was just an injunction to restrain threats. Was it more specific?
It was in it wasn't tab 9. It was to prevent threats. Paragraph 6, page 123, core bundle.
Yeah. So why would it make any difference to the injunction if he was right about distributors, wrong about Amazon?
Because if he's right, understand sorry, I now understand the question. It may make a difference to the inquiry, my lord, because there may be a difference on causation if the threats are to third parties, but not to Amazon themselves, because then different issues may arise as to
The
causation.
causation would depend, wouldn't it, on whether the communication, assuming it's a threat against distributors, caused the delisting of the products.
That's right. Caused.
I mean, suppose the first communication in January should be interpreted not as a threat of proceedings against Amazon, but a threat of proceedings against distributors. That threat against third parties would have caused the delisting, so it wouldn't make any difference, would it, to the inquiry? Carku, as the person aggrieved, would still be entitled to say, well, you threatened a third party in January. The result of that threat was that you, Amazon delisted the products, and that's caused us a loss.
My lord may be right. It would rather depend on whether or not, in those circumstances, the threat to a third party would have caused Amazon to delist a product. And there may be different
Threat, whatever it means, caused Amazon to delist the product.
if that is right, my lord. But one of the questions is, the judge held that the threat did cause Amazon to delist, but he focused on the threat to Amazon.
Yeah.
A threat to a third party, the question might arise, well, would Amazon alter, or did Amazon really alter what it was going to do and delist because of threats perceived against other people? Yeah. And there may be a difference there. I'm just saying there may well be a difference between the two. But my Lord Justice Arnold I take my Lord Justice Arnold's point and my Lord Justice Lewison that the injunction is framed in a broad, if like conventional way of not to issue threats.
Yeah.
My lords, my lady, I was going to start briefly with the law, but there isn't doesn't appear to be that much between us, if anything, between us on the law. Both sides accept that the purpose of the threats provisions goes back a long way to the 1880s, with cases. There's a case that my friend cites, Halcyon Brotherhood, where patent owners threatened customers. I think that was about steam engines, and caused loss in so doing. And Parliament provided redress by the threats provisions to prevent patent owners threatening, in effect, people's customers with patent infringement litigation, which causes those customers often to go elsewhere, and also where actions such as malicious falsehood or other forms of relief may not be applicable. And in the case of Quads for Kids, which the judge cites and my learned friend relies on, and I will come to later, which was a judgment of Mr. Justice Pumphrey, as he then was, at paragraph 24, he explained that it's wrong for somebody to go around saying, I will sue you for infringement of a patent unless you stop buying goods for X, because the natural response of anyone to whom that statement is made is to stop buying goods from X. So it's saying in the same way. But always one is assessing in a given circumstance whether or not the communication would be understood in that way, having regard to the circumstances. And there's no dispute before you that it does not need to be express, and it can be, in the phrases used in L'Oreal, veiled or covert, and it can be conditional or it can be future. It all depends on how a reasonable person in the position of the recipient will understand it. Now, the law and the statutory provisions are set out by the judge in the judgment. We can go to them briefly, but as I say, I'm not going to spend time on them. And they are in tab 7, page 106. Where the judge sets out the statutory provisions as they now are, section 70, and then the amendments that have been made since 2017. And you see now section 70 defines a communication containing a threat of infringement proceedings if a reasonable person in the position of a recipient would understand from the communication that a patent exists and a person intends to bring proceedings against another person for infringement of the patent by an act done in the United Kingdom or an act which, if done, would be done in the United Kingdom. And the threats provisions, as I say, are aimed primarily at customers, and although it's not set out by the judge here in full, Section 70A provides that to be actionable, the threat needs to be against what are considered secondary infringers, and that was brought in by the Banks Committee in 1977, and then that's been amended so that even if a threat relates to someone who is a primary infringer but does secondary infringement, so doesn't just make, import, or use the process, that is also not actionable. So again, it's focusing the provisions at effectively customers, and that is in Section 70A, although not fully set out by the judge there. And also there are some permitted purposes and defences which are not before you today and are not relied on.
Well, isn't Section 70B(4)(a) a fairly clear legislative steer about what you shouldn't be doing?
We see a little differently from that. We see that whilst that is a safe harbour as to being something that if...
Well, it's not a safe harbour.
Well, not a safe harbour, but what we say is it's not saying you shouldn't do that, and I'll show you the judge didn't take it that far, and we say he was right not to. What it's saying is a permitted purpose. So if you want the safe harbour, if you're in a permitted purpose, then that you can't be requesting a person to cease doing for commercial purposes anything in relation to a product or process. But we say it's not right that just because a communication does relate to that, it is a threat. And for whether it's a threat, one has to always go back to whether a reasonable person would consider it such. We do accept that the way that the statute is set out is the definition of threat is wide. We're not suggesting, we're not seeking a narrow definition. We're saying the definition is how would it be understood in all the circumstances. Now, just to cover off two matters that were run by Carku below but not advanced in this court, and the first you see in the judgment at paragraph 220. And this may relate to the question you've just put to me. He says that Carku relied on the decision of Mr. Justice Lewison, as he then was in Zeno, where my lord made similar points about carve-outs and the main provisions. And then at the end, the judge said, Carku suggested that Zeno was authority for the proposition that a request to stop selling a product is a threat. I do not accept there's any black and white rule about that. The question is whether there is a threat. Such a request may well be a threat, and the communication in Zeno plainly was. And my learned friend does not say the judge was wrong on that in his respondent's notice, and we say the judge was right. One other point before we leave the law, paragraph 239 of the judgment. This is not in the section on the law, but relates to the approach. It actually starts at 238 on page 115, where the judge says that he has, in the first paragraph, because the notifications must be understood according to how they would have perceived by a reasonable person, neither party adduced evidence from Amazon on their subjective views. And then in 239, he says Carku went further and submitted, again relying on Zeno, that because the communications have to be interpreted according to what a reasonable retailer would understand by them, Amazon's particular setup, and in particular its IP policies, are irrelevant, and the judge rejected that. What is left out of consideration is the subjective thoughts of Amazon, but their commercial arrangements and procedures are objective matters and relevant if they would condition how the communication would be understood. And we say the judge was right on that, and my learned friend does not suggest otherwise. So turning to the facts, inevitably the focus of this appeal is on my client's communications to Amazon and the fact that Amazon delisted Carku's products from the Amazon website. As I've said, my learned friend refers to this as a profoundly unattractive position from us, and he points out that the judge at the form of order hearing was unimpressed and thought that we should not have made the communications that we had. Of course, by the form of order hearing, the judge had already formed the view that our communications were unjustified threats, and it followed from that he was unimpressed by the basis under which they were made. But we say it's important on this appeal not to muddle up whether we use the IPR policy fairly or correctly, or whether Amazon's decision to delist caused harm, or whether communications, and only we should be focusing on whether the communications would be understood as threats. If they were not, then anything else that flows from Amazon's policies or Amazon's decisions is not for today. And as I will develop, we say that Amazon objectively did not delist Carku's products because Amazon thought that our communications were threatening patent infringement proceedings against Amazon or against anybody else. We say it was done following IPR, its own IPR policy, acting on a complaint from one of its own first-party vendors, and I'll explain that in a moment, against a third-party seller. Now, as I've said, Carku used the same Amazon procedure against my clients during the same period, and also had my clients delisted from the site, and that's relevant because the judge refers to, and my learned friend relies on, an indemnity which Amazon requested from us. And so we do need to look at those circumstances. Now, those complaints of patent infringement by Carku have not been tested because Carku have not sued on them. But it does, in my submission, illustrate a danger of taking wider context points, as my learned friend does. And the judge, actually, we say rightly, resisted the temptation to consider wider issues as to the application of the threats provisions generally to online markets, and focused on the facts of the present case. We say he was right to do so. We say he arrived at the wrong answer. And as I've said, my learned friend does seek to cast the net wider, but we say if one's not careful, one runs into some quite difficult problems. It's Amazon that can decide whether or not to sell Carku's products, and my learned friend has, his clients have no right to sell on the Amazon marketplace. My learned friend's clients knew that when they decided to sell via the Amazon website, and it's clearly set out in the terms that they could be delisted. And they decided to sell there because there's obvious benefit in them in doing so. But it means that if delisting is more heavy-handed or one-sided than they would like, that is not a matter necessarily of threats provisions. It may be to do with wider issues not before the court today, and the threats provision should not be repurposed to obtain compensation.
Can I understand that submission a little more clearly? Is it your case that Amazon delisted the products for any reason other than the fact that your clients made the communications complained of?
My lord is right that they delisted them under their IPR policy following the complaint from us. If it's behind my lord's question, I'm not suggesting they delisted them had we not made those complaints. I'm not.
So you're not suggesting that there was any other reason for delisting?
They delisted them because we complained. What I do say is we say that delisting was not because they feared or felt threatened by litigation from us. They have a strict IPR policy where complaints are made, they consider them and will police their website. And as I'll come on to, they also had a closer relationship with us. And one of the points that is important to keep in mind is, and the judge does refer to it, that we are what's called a first-party vendor. Now, that isn't just that we have a close relationship with them in terms of a manager and close liaison. It's also that they buy our products wholesale from us, and they sell them on the website. So they are our products, when they get to the Amazon website, are in effect Amazon-owned products. They bought them. With our products, they buy them wholesale, and I'll show you the evidence, and sell them retail. And then because of that, and in addition to that, we're allocated a manager, and he has regular meetings with us and an annual assessment of the next year, and that's also in the evidence, and the judge refers to it. None of that applies to Carku and its distributors. So we say that Amazon's policy is where there is a complaint, it will look at it, says it will delist. Objectively, we say it did just that. It did also objectively have a commercial reason why it might wish our products to be on the market, more so than Carku's, because with one, it is.
How does that bear on the interpretation of the communication?
Well, it's context, and I was answering my Lord Justice Arnold's question as to why Amazon and what are the reasons for the delisting. And I was
how far we're concerned with what would be understood by a reasonable person in the position of the recipient, not necessarily the recipient itself. So what are the attributes of Amazon that you are attributing to this reasonable recipient?
In my submission, when looking at how a reasonable recipient would understand a communication, it is relevant to see who sent it, why they sent it, and what the relationship was with that person. Because any reasonable recipient would have those things in mind, if not explicitly in mind, then implicitly in mind, because that is part of how you understand the communication. And that brings me, my lord, to the facts. And before looking at the communications, I will run through what I've just said in a little bit more detail as to what we say is important context. I've summarised it, but I will just, if I may, take you to that. And starting with the context in which the communications were sent. Amazon, as you would have read and know, have a policing policy, which they say on their website, concerning IP infringements. And it is heavily focused, it is true, on counterfeits and brand, but it is also other types of infringements, including patents. Now, the procedure is described by the judge, and we can take it from the judgment at paragraph 234, which is on page 113 of the core bundle. And he explains in 234(1) that it has this IP protect property policy, which states that it provides protection and safeguarding measures for intellectual property rights holders. Under the policy, any proprietor of intellectual property rights is able to file complaints with Amazon via its website using an infringement form. It also operates what's called a brand registry, which there's no dispute, despite its name, does cover wider rights. And companies are encouraged to register to use that, but it's not accessed by all rights owners as a matter of course. And then he mentions what I've been saying, this first party or 1P relationship that NOCO has with Amazon, meaning that Amazon buys products directly from NOCO to sell on Amazon's own account and is registered with the brand registry. And that status means that we have a contact person referred to as our category manager. And then he says in 4, what I've just submitted, that the brand protection report appears focused on brands and counterfeits, but actually covers all IPR, including patents. And it is worth, in my submission, just briefly seeing what Amazon say about it, because it is important to the context of how the communications were received and why. And my lords and lady will find that in the supplemental bundle.
Can I ask why the entirety of this supplemental bundle is designated as confidential when it includes all sorts of pages on Amazon's website?
That is a very fair observation, and one I, at the moment, don't know the answer to, but I completely understand my Lord's point, and I will find
Well,
that.
if one looks at the index, I think it's simply to reflect the fact that
It has-
two of the items in the bundle are confidential, tabs 29 and 31.
Exactly, and so I was about to say, I think the confidential material was Zhang 1 and Zhang 2, but I can't say, I'm afraid, why the whole bundle was. It should not have been, obviously. Apologies for that matter.
And even if one looks at those statements, they're not all confidential. Bits of them are.
I take my Lord's point, and we will look at that. I haven't asked for a 31/22.
Well, I don't think we're going to have to. We're not going to have to refer to the bits of the witness statements which are confidential.
I think that's right, and I think it's my learned friend's confidential information if it is confidential. But
yeah.
I take my Lord's point. Tab 35. I was going to go to, which is in page 150. This was what the judge was referring to. This is the brand protection report, and the relevant passage is on page 159, where it talks about helping protect utility patent owners. Utility patents cover the inner workings of a product, its technology, its design, can be complicated, and they have a neutral evaluation process where they evaluate to determine if they believe a product is infringing. The process is an efficient means for patent owners and those accused of infringing on a patent to address the concerns, and faster than the court system and free for a party that the evaluator determines is correct. So they put forward the system as almost like a form of ADR, but they say that they will look at it and consider it. And the judge accepted they do, on the whole, seem to do that, different from other online marketplaces that we know of in other cases. I'm thinking in particular about eBay.
Well, this only covers certain United States patents, as I understand it. And it brings in a third party, neutral third party, to do the evaluation.
Except that it is very US written, I agree with that, accept that. This is on, I believe this is from the European and UK website, but my Lord is right that it's read in quite a US way, and I accept that, I have to. My Lord, they do, however, suggest that and encourage people to use their IPR procedure. And one sees that in the two forms that they have. They have a general form for those not enrolled in the brand registry to make complaints, and that is in Supplemental Bundle tab 19. On page 64, if you're online, you see at the top it talks about if you're a rights owner with a registered trademark, you may be eligible to enrol in the brand registry, and as we've seen, that is actually broader than trademarks. But there's also this infringement form more generally, and it's a longer form than if you enrol in the brand registry. And for those enrolled in the brand registry, such as my client's NOCO, the form is simpler, and you'll find that in tab 41. Unfortunately, it's, at least in my copy, it is photocopied sideways on. But you should there in page 195 have a report of violation form, and then it says it asks you for the type, where the website is. It asks you for to complete an ASIN, that stands for an Amazon Standard Identification Number about the products, and then it allows you to fill in who you are, and also provides you with a space at the bottom to give some information, up to 3,000 characters. So that is the form that they put out, and they invite brand owners to use it, and we see that in tab 38. Which is page 188. It's not terribly clear on mine, but there should be again a printout from the website called Amazon Policies and Processes. And they say they do not allow listings that violate intellectual property rights of rights owners. They refer the reader to Amazon's intellectual property policy and encourage rights owners who have concerns regarding the misuse of their intellectual property to notify us using a report a violation tool, which we've just looked at in the brand registry. So they encourage those rights owners on the site to use the form. Now, reliance is placed by my learned friend on their terms and conditions, and so it's right that I show you those, which is in tab 10. There are a number of different versions in the bundle, I noticed, of the terms of conditions. I'm taking tab 10. I think they show how they were changed. My learned friend can make a point if he says that they matter, the changes matter. I was going with the conditions as of January the 29th, 2020, which is in tab 10. And this is the conditions of use to those who wish to use Amazon's services. On page 35, you see again in little under section 9, heading 9, intellectual property claims, that Amazon respects the intellectual property of others. If you believe your intellectual property rights have been used in a way that gives rise to concerns of infringement, follow our notice and procedure for making claims. And then on page 37, in section 19, they talk about, in their terms, the notice and procedure for making claims of right infringements. And we see that if you believe your intellectual property rights have been infringed and you're eligible for brand registry, please sign up to that service and submit your complaint. Otherwise, submit your complaint using the online notice form, and I have shown you those. And it says they may be used, this form may be used to report all types of intellectual property claims, including but not limited to copyright, trademark, designs, and patents. They say that on receipt of the complaint, they may take certain actions, including removing information or an item from the website. And they say, and this is my learned friend relies on, all such actions are taken without any admission as to liability and without prejudice to any rights, remedies, and defences, all of which are expressly reserved. And they then say this includes forwarding the complaint to the parties involved, and you agree to indemnify Amazon for all claims brought by a third party against Amazon arising out of or in connection with the submission of a complaint. And that's, in my submission, focusing on if they action the complaint, for instance, take down the material, then there's an agreement for an indemnity. And then they put a note that some are third-party seller listings and they're merely hosted on Amazon and are posted solely at the direction of the third-party sellers. And that's my learned friend clients are third-party sellers. Now, these are the general terms and conditions to everyone, but as is indicated there and as I have indicated, there were different classes, if you like, of sellers on the Amazon website. We've seen some are part of the brand protection registry and some are not. But there's also this difference between first-party vendors and third-party sellers. And if I may just deal with that now, because I say it's relevant, because Amazon or a party in Amazon's position, when receiving a communication from us, it is relevant in my submission that it's coming from one of its first-party vendors. And what does that mean? And for that, I've trailed that from what the judge said, but just it's worth seeing the evidence on that because it's brief, and that will be in tab 30 of the supplemental bundle. And so I hope not to trespass on your time. and it is page 113. This is a witness statement from Mr. Nuke, who is from NOCO. And in paragraphs 8 and 9, he explains what it means. And a first party, he says at paragraph 8, the parties are either first party 1P or third party 3P relationship. The 1P relationship, the vendor has a direct relationship with Amazon. Amazon buys the vendor's product wholesale, handles the selling details, unlike third party relationship, where they do not have a direct relationship with Amazon. The seller is an independent seller on the marketplace. And I ask you to note that he points out here that NOCO has been a 1P partner of Amazon since 2014. So for 6 years before these communications, we've had this relationship with Amazon. And it's not just that they buy our product and then they sell it on their website. It's that also we have an ongoing relationship with them. We have a category manager. This is what he says in paragraph 9. He speaks regularly, or NOCO's representatives speak regularly with that category manager, discuss aspects of the business, and have an annual meeting on terms and conditions. So, and then he says in 10 that 1P partners are encouraged to sign up to the Amazon brand registry, and I've shown you that. So we say this is a case where it's very important to keep in mind that the recipient of the communications was getting them both by a form that it encouraged people to use and from one of its long-standing, 6-year standing partners who it worked with, had regular meetings with, and bought the products from. And we say that is important background as to why we say Amazon is not going to feel that that 1P vendor using that form was threatening Amazon. Now turning to the communications themselves, NOCO used the form I have shown you to complain, and you have a typical record of the complaint in supplemental bundle tab 2, which is on page 15. And this is how it is logged in by Amazon. You see, I won't go through it all, but you see that a patent has been cited, 858, a violation has been recorded, and then the additional information I showed you there is that area where you could type additional information, and here it's the registration number for our utility patent, 858. Please remove these Amazon standard identification numbers. And the judge recorded that most of the complaints was either that wording or a very similar version of it. He records at paragraph 234 little 8 that from July 2020 the wording was changed to say these ASINs infringe on our patent. We have a legal letter from Amazon's legal team stating the legitimacy of this claim. I will escalate this case to provide that letter. Please remove these ASINs. And that arises from a letter that Amazon wrote, which I will show you. But in effect, the judge did not put any particular difference between the various communications, and they all came to the same effect. And we say he was right about that.
The report of violation form, which you showed us on page 115, I think was the relevant form, wasn't it?
That's my understanding.
There is a slight difference between that and page 15. But it was this one, wasn't it, that I think you said was the...
I thought it was. What's the difference? I can then check that
the
one.
difference is, on page 195, it says, please provide more information on how the reported products are infringing your right. And on page 15, it simply says additional information.
I had understood that what you don't have in front of you is the form that NOCO submitted. What you have is the report, my understanding is what you have is this report of how Amazon logged the complaint. And so the log comes in additional information, and there's the information. My understanding is that's what would have been written in the box, but you do not have the complaints.
That doesn't answer the question though, does it? The question posed by the form is how is the reported product infringing your right? How? The additional information says remove these ASINs. Now, that's not answering the question how are these products infringing. That's asking Amazon to do something about them.
My law may be right on that, but this is what was recorded as to
Yes.
what. Not,
But your understanding is that it's the form on 195
that is my understanding. Those behind me
was the form that NOCO filled in.
That was my understanding, and those behind me are nodding
Yeah.
previously. So what I think the judge did refer to this, NOCO did not have, and actually neither did Carku, the actual
No.
records of what they sent in online. I think they didn't keep them. They fill in a form and press send, and Carku did the same. So we don't have a record of either what they wrote to Amazon or what we wrote to Amazon. What we do have is the complaint details that you see in tab 2. I take my lord's point, but I can't really answer it effectively other than what appears to have been sent into Amazon is, as you see there, the registration of our utility patent is X, and please remove the ASINs. Of course, that's what the whole purpose of we accept that, the IPR procedure in this form was about, which was notifying Amazon of potential.
Well, it might or might not be. Part of your case is that Amazon do their investigations. So, it might have been said, well, we think this product infringes our trademark or patent or whatever it is, please investigate.
Well,
You say there's an infringement, take the stuff down.
Although we do know that Amazon investigates, and the evidence from NOCO was of its complaints to Amazon generally. I think over a 6-month period, it made quite a number of complaints, and I think the judge records about 70% of them were actioned, and about 30% were not. And so it does assess them, and that was what Amazon says it will do, and it does. And one of the points the judge put against my clients, in my case, is that actually, for our case to work, he said it needed to be automatic. And we don't agree with that, but the judge accepted that Amazon does review the complaints, and there is evidence here that I think the judge refers to it, claim charts being considered. So Amazon did review them. I take my lord's point. It's not saying, will you please review this on these words, and I take that point. But
would you accept that this is a form of notice and takedown? Of course, as you say, this is not operated by Amazon in a way whereby they automatically delist anything that is complained of, and no doubt for good reason, because they want to encourage spurious notifications. But nevertheless, this is a notice and takedown procedure, isn't it?
It depends what you mean by notice and takedown. What this is, in my...
Well, let me be more specifically. This is intended to be compliance with Article 14(1)(b) of the e-commerce directive.
Understood, my lord. We would say what this is the rights owner doing what Amazon had encouraged it to do, reporting that it believes that there is an infringement, and doing what Amazon have said it should do, which is to write and request that is a violation. And Amazon has said one of the things it will do, or could do, is look at that and take it down. And that is what we have requested. And we say that is all part of the Amazon IPR policy.
Well, I understand you say it's part of the policy, but can I be clear? Do you accept that this is notice and takedown within Article 14(1)(b) of the e-commerce directive?
I will need to, before I could accept that, I would need to have a look at how that has been interpreted, because I don't want to say yes to my lord when that hasn't been been raised, other than by my lord. And I don't want to say to my clients
Well,
yes.
Okay, let
So
me
I
leave
don't-
out the e-commerce part. Would you accept this is a notice and takedown procedure?
Well, the Amazon procedure, which it encourages people to use, includes an ability to give notice and for that to be taken down. That is the Amazon procedure. And we are encouraged to use that, and we have done so. And Amazon have said that they will look at it. I showed you that. And indeed the evidence, and the judge accepted that evidence, that it does. And in 20% of at least in the snapshot of our complaints over 6 months, I think it was 30% actually, that were not actioned. And that, we say, goes to whether or not Amazon is, the Amazon system involves an ability to give notice and to have matters taken down. But in my submission, that is a different question to whether Amazon would consider someone using that as threatening Amazon. They are not the same question in my submission.
Well, can I ask you this question? Let it be assumed, for the purpose of my question, that Amazon is intending to comply with Article 14(1)(b) of the E-Commerce Directive. The purpose of it doing so would be to immunise it from liability. Why might it wish to immunise itself from liability?
My lord, where I part company with what my lord has just said is we don't accept that it is the purpose, or objectively the purpose, of doing so. I hear, my lord, there may be an effect of so doing, but we say that what's loaded, and I don't mean that rudely, in that proposition, is that Amazon is indeed thinking in terms of needing to immunise itself from liability. And that goes back to his saying that is not the way, objectively, a reasonable recipient receiving one of these forms from one of its partners who it's worked with for 6 years and bought products from for 6 years would consider to be the case. So I think I don't, with respect, accept the premise of the proposition. My lords, I was going to turn, having shown you of a typical record of the complaints, and we know that a number were made between January and April 2020, leading to Carku's products being delisted. And we say that not, and you have my points on this, going to be viewed by Amazon as threats to bring patent infringement proceedings against it. That is not the purpose of the forms. They're encouraged for policing the online marketplace. And it's not likely that one of Amazon's 1P partners would be using the Amazon procedure to that effect and would not be understood by a recipient in Amazon's position that that is how they are being used. Now, the judge held that Amazon will have considered its own self-interest, and both in how it records its outward-facing materials and in how it acts, and we accept that any company does operate plainly in its own self-interest to a certain point, a certain extent, and we also accept that it is likely objectively that Amazon's outward-facing materials are going to cast it in a good light, not in a bad light, and we accept that, if nothing else, as just a common sense approach to how companies will act. Where we part company is we say it doesn't follow from that the self-interest concerns fear of patent infringement litigation, or that it is feeling threatened by one of its 1P partners. And that's where we part company, and we say...
Another question, which comes back to a question my Lord Justice Lewison asked at an early stage, because one of the curiosities about this case is that the statutory test is to look at the impact of the communication on a reasonable recipient in the position of the actual recipient. And obviously, that gives rise to a question as to the extent to which you attribute to the reasonable recipient the actual knowledge of the actual recipient. And there's been quite a lot of focus by both parties on the actual position of Amazon, and that, to some degree that's understandable. Now, let's assume, for the purposes of my question, that it is indeed proper to attribute to the reasonable recipient the knowledge and attributes of Amazon, leaving aside its subjective thought processes. Common ground, one doesn't look at those. Would you accept on that basis that one of the background facts that is relevant to take into account is the fact that Amazon is sued daily for intellectual property right infringements, particularly trademark infringements? I say daily, that's obviously a figure of speech. It's sued regularly for trademark infringement.
My lord, plainly, and I know that's not the basis of your question, but there isn't evidence of that in this case, but I take that my lord's question is wider than that, and we assume for a moment that it is.
Would you dispute that that's something we could take judicial notice of, given that this court has heard such a case and is currently pending before the Supreme Court, and we've got judgments coming out of the Court of Justice, we've got judgments coming out of other countries in Europe. I mean,
of course, my lord.
Judgments coming out of the US courts.
Yeah, no, my lord, I do accept that, my lord, and I was just pointing that out for the record, but I do take, as I said, I take my lord's point. What I would say, I do accept that Amazon is in litigation.
So just a minute, I haven't quite understood your answer to my lord's question. Are we to attribute to the reasonable recipient that Amazon is regularly sued for IPR violation in one form or another? Or is that something we have to leave out of account?
In my submission, if one takes into the attributes of Amazon, of the areas that I've been saying, I think it is also follows that one takes in attributes that Amazon is sued regularly in IP. In my submission, it wouldn't be sensible to divorce one and include the other. I accept that. However, again, one has to look at the general and the specific, because there is a very different, in my submission, matter going on here. Because again, it comes back to the 1P partner status. I don't accept, I don't know, there's no evidence about whether Amazon is regularly sued by what it calls 1P vendor partners who he works with, or who it works with. And that, in my submission, would be too far to say, well, we take judicial notice of that, because there is no evidence in this case about that, and I can't submit that or accept that that is appropriate for more general judicial notice. Moreover, what we do know in the evidence of this case is Amazon rejected 30% of NOCO's complaints in a 6-month period, and there's no evidence of ever being sued by NOCO. And we say that's not happenstance, that actually supports our position that neither NOCO nor Amazon, as between them or a party in Amazon's position, would be thinking about being sued by one of its 1P partners. It hasn't been sued before. It is not a relationship where suing is on the table. It is a collaborative relationship and has been for 6 years. And this is not a sort of collaborative relationship where suddenly your co-partner writes out of the blue telling you about patent infringement in a way that either is express or might be taken to be an allegation against you. It's a situation where your partner is doing what you've encouraged it to do, to report where it has complaints on the Amazon website, and this is about third-party products. So my answer is yes, of course you can take judicial, with respect, take judicial notice of the general proposition, but it's not far to take it to the specific. And the specific matters, it goes back to knowing who sent the communications, in what context, and why. Now, it is said that an example of how Amazon does have an eye, and perhaps more than an eye, on its own liability is the fact that they requested an indemnity from us in relation to Carku's products, and I need to look at that because that arose not from any complaints we made, but that arose from Carku's complaints about our products, which were then delisted. Now, the context is immediately different, you may appreciate, because here Amazon has got receiving a complaint from a third-party seller, one with whom it does not have this relationship. And there are, of course, probably thousands of third-party sellers on the Amazon website. And what Amazon is doing with those people or those companies is simply hosting and providing the service of an online market.
Well, I mean, there clearly is a relationship. I find this reference to no direct relationship a little difficult because there obviously is a relationship. You'll say it's a different one.
I take the point. There is
Amazon presumably acts as agent in hosting the products.
There are definitely contractual relations between them. I mean, this was explored in the lifestyles case. So yes, the contractual relationship is different, but there is nevertheless a contractual relationship.
I accept that because plainly there'll be a contractual relationship, although I don't think it goes into the evidence here. There will be a contractual relationship if you're going to sell products on the Amazon website. I accept that, my lady. And maybe I was taking my reference from the evidence, but I accept that there is a relationship, and I hear what you say about what is meant by direct relationship. What I mean by it, and what I submit, is that there is a difference between a third-party seller, of which there are who knows how many, where you have contractual relationships because you're hosting and allowing them to sell on the marketplace, and a party from whom you purchase products to sell yourself on that site, and then, as we've seen, as part of that, have an ongoing relationship in the sense of a more human relationship, if I put it that way, which is having your manager, having regular discussions, having annual terms reviews. And we say that does matter and is relevant because it goes to how Amazon or a company like Amazon would respond or understand the communication that has come in. But that is how I am using the different parts of the relationship, my lady. I don't know if that assists, but now the one of the problems with considering the indemnity, and as the judge referred to, although he did continue to refer to the indemnity, was that we don't know what Carku said to Amazon, and we don't have any evidence at all about what they wrote in their complaints. And the judge did refer to that and explain that was the case. He did so in paragraphs for your note 242 and 253. So one has to be very careful then about drawing conclusions from Amazon's reaction. We don't know what was said. What's relied on is what is said in tab 16, page 56. Here, Amazon write to NOCO about the fact that this complaint has been made about NOCO branded ASINs, which until recently have been sold on our European stores. The rights owner, Carku, has notified us the products are infringing their patents, and following our internal policies, we've made the decision to remove the products from our European stores. And this, they say, is because we are typically not in a position to assess the merits of third-party patent disputes. So here there does seem to be a difference between the assessment of a 1p and a 3p party dispute.
Sorry, are you assuming that is what that's referring to? The difference
In
between-
my submission, when Amazon do seem to use 1p and 3p and third party in those terms, and in my submission it does appear that they are taking a different view. I'll show you how they actually responded to Carku in a moment to show that a different approach was taken. And they say that they understand that in the opinion of NOCO, the products do not infringe the patents, and that being so, in order to exceptionally enable the reinstatement of the effective ASINs, we would require your adherence to an arm's length indemnity terms as set out in the document. And before I make submissions on it, I will show you that, so you have it. That's in the next tab, I believe, on page 59. And you'll see that that is an indemnity because of an allegation that the sale of the products on various websites infringe 2 European patents of Carku. Now, we say, as I've explained, one of the problems in reading too much into this or anything into this is that we don't know what Carku said. But also in my submission, objectively, one could see how a different position may arise, because this is now a complaint by a third-party seller about products that Amazon itself has purchased and are selling on its website. And one can see that that may objectively cause a different position to be taken. And objectively, it appears that it was, because we see that whilst we were offered the opportunity to put our products back on the market, and this is obviously Amazon-owned products that they buy wholesale from us, Carku was not given that opportunity by Amazon. Nor is there any evidence or suggestion that Amazon said to Carku, you could write an indemnity and we could put the products back on. And in my submission, if in fact what was behind the concerns of Amazon about our complaints was a fear of being sued by us, a way through that would be to do what they do here and say, well, could we have an indemnity, please, Carku? And they never did that.
But aren't we speculating? Because a simple reason for not asking for the indemnity may be, in the case of a so-called one-party relationship, you've got a better idea of the scale of the organisation you're dealing with.
I accept that.
In terms of, it's not just a piece of paper.
Albeit in opening my appeal, I am answering a point that's been made by the judge and by the other side about this indemnity. I'm explaining, I'm with you, my lady, that it is very dangerous to speculate because we don't know the circumstance of this. What's important is this does not relate to our complaints. Now, we do rely on the fact that nowhere is there evidence of Amazon asking the same indemnity for Carku. I do accept my lady's point that we don't know the background, but that goes again to my overall arching point that therefore one should not be relying on this at all, because we simply don't know the circumstances of it and what Carku said. And we don't know, of course, what Amazon was actually thinking about it. What we do know is that they did write, and this is referred to in the judgment, and so I'll show it to you because it helps to understand the judgment, at tab 44.
In any event, I mean, whether Amazon offered the indemnity route to Carku can only bear upon Amazon's understanding. So how can the interpretation of the communication as to whether it's a threat or not to a reasonable recipient depend on how Amazon understood it?
I accept that, my lord, and again I go back to our position is that should not be taken into account as to what they were thinking they were doing with Carku, because we we don't know enough and we get into subjective.
Well, the point about the indemnity surely is not the fact that that is how Amazon responded to particular communications, which, as you rightly say, are not in evidence. But what it demonstrates is confirmation of an obvious proposition, namely that one of the things that a retailer can do when it receives a request to take things down is to request an indemnity.
Of course.
So it's confirmation of what one might have thought to be self-evident anyway.
I accept that, my lord, and whether or not they would or think about that depends on how they react to the communication and how they understand the communication. That goes back to us not knowing. So I was going to just take you, before I move on, looking at the time, to tab 44, because the judge refers to this letter, and therefore when reading the judgment you may have seen this, but it will assist in understanding it, which is at page 202 of the supplemental bundle. And this was following complaints by Carku and its solicitors, Pal Gilbert, about the delisting, and they wrote to Amazon, and the judge refers to claim charts and the like coming in, and Hogan Lovells, on behalf of Amazon, wrote back to say that they had, this is in the middle paragraph by the lower hole punch, that they had assessed the patent infringement and the other allegations presented by each party, and following the exercise they concluded that those made by NOCO regarding the infringement of its patent are sufficiently grounded to justify delisting, and they say that if Carku wishes to revisit that, they need to provide a judicial decision saying they don't infringe, or that NOCO's patents do infringe, in order to delist NOCO. So,
it's delist now, investigate later.
That is Amazon's position. And that goes back to my contention at the outset, my lord, we must, that we're divorcing whether or not Amazon, how Amazon approaches its policy is not the matter before this court. It comes back to whether or not Amazon understood the complaints to be threats. But yes, my lord is right. They're saying delist now. Well, they're saying in NOCO products, carry on listing unless you have a court decision against NOCO. And with Carku products, you delist unless.
Sorry, I apologise for asking a question for a third time, but I need to be clear as to where you stand on the law. And let me put the question on this way. Do you accept that it is open to a court to hold that a particular communication is a threat because it will be interpreted as such by a reasonable recipient in the shoes of the actual recipient, even if the evidence demonstrates that the actual recipient did not understand it to be a threat?
Sorry, my lord, I'm hearing whispering behind me, and it seemed an apposite moment to listen to the whispering, if I may, my lord.
Yes.
Yes. In my submission, it is open as a matter of law.
Well, it would follow from the Manai case, which is referred to in Best Buy.
Exactly right. So I can't say it's not open in law. Question of whether it's appropriate to do in the facts of a case, of course, is a matter for an assessment by the tribunal. But I can't say to I can't submit to my Lord Justice Arnold or to my lords and lady that it is not open in law. However, in the circumstances of this case, we say that a reasonable recipient in Amazon's position, in the way that I have submitted, my lords and lady, that should be understood, not viewing as threats against Amazon. And it would be a rather surprising in my submission suggestion that suddenly they would think that their 1P partner, using the form they're encouraged to use, was actually threatening patent infringement proceedings against Amazon itself. Now, the judge's reasons I can take relatively quickly because they're relatively brief. I don't mean that's actually a criticism of the judge, but it's they are. And so we could look at those in the judgment in tab 7, page 118 in the core bundle. And he sets out his analysis section from paragraphs 250 through to 258. I can ask my lords and ladies to read that again, or I can take that as read. I was going to take it as read, but if you'd like to read it again, then please do indicate. But in my submission, they boil down to 3 points. The first is because Amazon does not delist automatically or blindly, it indicates a level of self-interest in the decision and an eye to patent risk. And that you find in effectively 252 and 253. And he goes as far as to say for our case to work, we would have to have shown that Amazon delists automatically. He says that in 251. The second is that we never gave an assurance we would never sue, and Amazon, whilst it thought it might think it unlikely to be sued by a 1P vendor, could not rule that out. And thirdly, he talks about the issue being freighted with lawyers and claim forms, claim charts. Sorry, not claim forms, claim charts and the like. That's in 254. As to the first, we say the judge was wrong that for the case to work, Amazon must delist automatically. In fact, we say, if anything, the fact that they do not is in our favour. If it was concerned about being sued, the path of least resistance is to delist automatically. On the evidence, as I've said, Amazon has rejected about 30% of NOCO's complaints, and that's recorded in the judgment at paragraph 247. The judge points out we don't know the reasons for the rejections, but as I've submitted to my lord and my lady, we rely on the fact that actually a party in Amazon's position would take note that it had never been sued in any of those. On his second reading reason, as summarised by me, the judge finding that Amazon might...
So suppose that the reasonable recipient thought, well, I may well get sued, but the action's bound to fail and I'll get indemnity costs, so I really don't care. That's still a threat, isn't it?
I think, yes, I think my lord put it, if you think, well, as you say, I might well get, this sounds like a threat, I'm being sued, but I'm not too worried about it, you are still understanding.
So why does it matter what the recipient does in response to the communication?
Well, that goes back, my lord, to my primary position that what matters actually is the context of the communication. And we say that Amazon would not think in those terms. So Amazon is not thinking, I might get sued, but I'm not worried about it. It's not being, it doesn't think it's going to be sued by one of its 1P partners at all.
But you're criticising the judge, and I understand the criticism of paragraph 251, but why is it relevant whether Amazon does or doesn't delist automatically in interpreting the communication which it in fact received?
I take that point. I do take that point in that one can read it both ways, and that's one of the reasons one doesn't go subjectively into what Amazon might think, and I accept that point. I was answering the judge here, and we say it's not right. He's wrong that it matters that they did it automatically, because automatic delisting could be because they're concerned about threats, or it might not be. And likewise, we accept that non-automatic delisting could be because they're concerned about threats, or it might not be. So one can't read into it one way or the other, but accept that. What I do say one can read into, and is legitimate to read into, is where a company does refuse to delist from a particular party, and has never had a problem, that is relevant in its understanding as to whether it is likely to have a problem. So we say that is something one can read in, but I accept that what the judge's point we don't agree with, and I agree with my Lord Justice Lewison on that, one can read both ways on that, and therefore it doesn't assist. I do say that actually, if one was to take it into account, it supports us more than the judge's point, but I take the overarching point my Lord has put to me. In relation to his finding in 254, that Amazon might think it unlikely it would be sued, but could not rule out being sued, our concern here, it rather depends on what he means. If he means that a party in Amazon's position would view this as a threat to bring proceedings at some point in the future, then we accept that that is open and that is something that would be a threat. Where we would depart company is if he means that you would not think it's a threat, but you couldn't rule out being sued by this person in the future. Amazon might well make the judgment as unlikely to be sued, but I was not pointed to any reassurance by NOCO that Amazon would never sue. And he talks about what happens if enough alleged infringing product was sold so that NOCO might not give in to greed or commercial necessity and sue. We say that's going far too far. That's looking at what might happen if a commercial relationship broke down or if the circumstances changed. And we say one's got to look at the circumstances when the communication was sent and decide would they be viewed as a threat. And we say it's not right to start postulating that they might think it's unlikely, but at some point in the future they might be sued. And indeed we say that if one is going to rely on the fact that no reassurance was given that it was never sue, that again supports us, because it does actually support a position that these parties are not thinking in terms of suing. And indeed, Amazon might be rather surprised if one of their 1P partners in 6 years puts in a form like this and then gives a reassurance we're not going to sue you. Suddenly suing is hanging in the air. And we say that isn't how these parties would think at all. So again, we depart company there with the judge. As I've said, in the middle of 252 and 253, he talks about the documents from Amazon being outward facing, portraying Amazon in the best light, and he talks in 253 of Amazon working or operating to its own self-interest to a greater or lesser degree. And we don't depart company with the judge there, save that we don't accept, as I've explained, that the reason for the self-interest is to do with fear of being threatened by us. And so we say that's where we depart company with him. And in the middle of 253, he refers to the indemnity offer. The judge does say that he does not know the context, and in particular what Carku had said, but he does still have it there and says there is more than enough there to divine that Amazon makes a judgment in its own self-interest, and not, that seems just going back to not delisting blindly. As regards to the end, and I've shown you the Hogan Lovell's letter, which he refers to at the end of 254, and his reference to freighted with claim charts and lawyers. And that actually, again, in my submission, simply goes back to the fact that there's no delisting blindly. Both parties then came in with their respective positions, both us about our products and Carku about their products. But we say that isn't relevant to whether or not Amazon would actually think, or a party in Amazon's position would think that we were so threatening them with litigation, patent litigation. Now, the judge also held that the recipient of these communications would have viewed them as threats to bring patent infringements against the third-party distributors. That, my lords and lady, will find in paragraph 256. It's quite brief, but he says that if he's wrong, that a party in Amazon's position would think of itself as being threatened. He says the position in relation to third parties is absolutely clear, given the communication of February 2020 quoted above, and he says that we had no rational answer to it, and Amazon will understand that if carried on selling, NOCO would be ready and willing and able to sue the relevant third-party distributors. So for this, we need to see what he was meaning about the February 2020 quoted above, and you find that in paragraph 236 of the judgment on page 115. And what the judge does is he sets out there a communication between NOCO and Amazon about, he says, about NOCO's having sued third parties, and he quotes from the middle there from Mr. Nuke to, I can't pronounce his name, but Mr. Ugurkan of Amazon. He was our contact manager. And it says, Carku has never brought a case against NOCO for these patents as they're not relevant to our products. We do continue to file lawsuits against companies that infringe on our safety patent. Some of these companies are, and then non-relevant companies have been redacted, but Gulu and Odoo are distributors of Carku, with new lawsuits being filed against someone, O-Town and many others. We have won cases against someone and reached a settlement agreement with someone, which is why we do not include them on the utility patent takedown. And then the judge says this was a few days before another batch of notifications.
So, first question on that, would you accept that the 3rd February email in itself is a plain threat of infringement proceedings against third parties?
2 points there. Firstly, it's not relied on for that basis. And secondly, no, because I'll show you the context in which it was written. Okay. And where I'm going with this, so my lords and lady know, is we say it was unfair how the judge took a part of an email from a particular context and placed it in a different context. And you see what he says in 237 was that this was a few days before another batch of notifications. And then finally, at the end of 237, he says the emphasis on continuing to file lawsuits against named companies and many others is strong and striking. And we say, well, it is in the way that the judge has set it out there in the judgment, but we say that's not fair with respect in how it actually arose. And for that, one has to see the context. And there, my lords and lady, you'll find in supplemental bundle, tab 13, starting on page 49. On page 49, you have a start of the email chain, which is not quoted by the judge, which is Mr. Nuke on the 3rd of February to his contacts at Amazon, his Mr. Ugurkan and Mr. Bavaro, and he's referring to the NOCO patent issue. So the context is Carku's claims against us. And he starts with see attached. For your note, that is tab 52. What you'll find there, we don't need to go to it now, but what you'll find there is a patent attorney setting out why NOCO's products are said not to infringe Carku's patent. So he starts with tab 52 saying, see attached. This is about as detailed as we can get to explain why these patent is not even relevant. What he's talking about is our takedown. Our products have been taken down. Please forward it to legal. And then our contact, Mr. UA, comes back to say, well, you've sent me that already. My question was also around, were there some findings in earlier cases you had with this third party in the US, in the EU, that you can show similarity with this? I will then combine all data and check internally what we can do. So we're saying we don't infringe these patents. Carku have alleged them. And our contact manager said, well, do you have any findings in earlier cases that you can send us that might give us comfort? This is then where we get the email that the judge quoted on 48. Carku has never brought a case against NOCO for these patents as they're not relevant to our products. So he's saying, well, they've never sued us, despite writing to Amazon and having our products delisted. He then, in my submission to show, to contrast, we do continue to file lawsuits against companies that infringe on our safety patent, and then we've got the quote that the judge set out. But this is a discussion with our, if I call it relationship manager or contact manager, about trying to get our products back on the market, on the Amazon market. It's not about our complaints against Carku. He then comes back and asks us, are all these from the US, are there any from Europe? And then Mr. Nuke replies, they're all in the US now, and then talks about someone being a bad actor. So the judge has taken a discussion, and sometimes in litigation, in my submission, one can take an email discussion in one context and it's suddenly put in a bundle like this, or in a judgment, and takes a different, makes it look different. This has nothing to do with our complaints about Carku, and it's not even sent to the same people, because as you will have seen, our complaints are sent by the Notice Dispute Department, and you see that is not the same department, and indeed one sees in tab 3.
Sorry, where are we going now?
Tab 3, page 16. The complaints, and this is a response to Carku on our complaints, are dealt with by Notice Dispute at Amazon.co. And so the judge, in our respectful submission, is aligning correspondence with our internal manager about how we get our products back on the market with forms that we sent in about NOCO's.
But you're doing exactly the same. You're saying we send in this form to Notice Dispute at Amazon, and Notice Dispute at Amazon must be taken to know that we are a first P partner. So in fact, it's you who are relying on, so to speak, the totality of corporate knowledge within Amazon. I mean, for all we know, the people who receive the notice have no idea who NOCO are. They just get a
I accept that point.
violation
I
form.
accept that point up to a point, my lord. I accept that. I say that Amazon do know who we are, and we're a 1P partner.
Well,
And
how do we know that?
we do see that with our letters. In fact,
Well, we know in fact that NOCO is a 1P partner, but how do we know that the people who receive the form complaining know that?
well, we do know.
If we are to assume that, then that can only be by, as it were, aggregating attributed knowledge to Amazon.
Well, except we know that NOCO sent the complaints and discussed complaints with the IP category manager. We know that when I've shown
Discuss
you,
Carku's complaint, because you're pointing
Yes.
out very strongly it's a different context.
it is, but we also saw that, for instance, when Hogan Lovells wrote, they brought the two together, and we know that they were looking at the two complaints at that stage together, and we know, and in my submission they know, and we know from the discussions, I showed you the letter, they refer to their complaints being a 3P. They know that we're a 1P. My point is that what one shouldn't do is take something said in a discussion when we're being asked what's happened.
That's a different point. I
And
understand that, but your second point was it's sent to a different person within Amazon.
I understand. Well, my lord, my primary position is that it is it's not reasonable of the judge, with respect, to take something that's said during the course of an email exchange about something else and say this shows that it would be taken as a threat.
Could I ask another question on the same topic? And I think it may be you accepted this point already, but let me check. Do you accept that Mr. Ugarken's knowledge is to be attributed to Amazon?
We
You
what
make
does
the
need to be-
point, the context is different, and I've got that point. But why should Mr. Ugarken's knowledge not be attributed to his employer?
Mr. Ugarken's knowledge, it comes down to how far one takes that, because one mustn't get too subjective, and it is an objective position. and where the court is relying on correspondence, it is right then to look at the context of that correspondence. The context is to a Mr. Ugarkan, but I don't think it's fair in my submission to then say, well, that is therefore just sent to Amazon, shorn of context. So one has to, if one attributes it to Amazon, one also must attribute the context in which it was written. And the context was being asked, are there lawsuits that might assist you in discussing our products being relisted? And if that is attributed to Amazon, then what Amazon understand from that is that in the course of a discussion about relisting our products, an email was mentioned how these companies both act, but it is not right that one would then, as Amazon, understand that email as saying, and when I complain, the complaints are actionable threats or would be thought of as threats, because the context is entirely different. It's answering questions that Amazon have asked in a different context. So if it is attributable to Amazon, so must the context be, and that's our point. And the judge didn't take the context, we say, with respect into account. He looked at just the phrase, the words used there by Mr. Nuke, without seeing why they were used, and that's importantly how they would then be understood. Now, finally, my lords and lady, I should say something about the existing cases which have considered communications and online marketplaces, and that is in particular Quads for Kids and Cassie Creations, because my own friend relies on them, and the judge referred to them, although we say the judge rightly said that each case must be decided on its facts. And he,
Right, so how does looking at the other cases
well, in
help?
that case,
The question is the legal principles.
I'm happy to proceed. You'll know and you'll be aware that both those cases, well, the Quads for Kids, although from plainly very highly respected
Well,
panel's
they're all
judge,
interim decisions by judges of lower courts which don't bind us.
of course, I take that, and I don't want to press it, but I didn't want it to be said that I hadn't dealt with them. So overall, our case is that in the circumstances of this case and our relationship with Amazon, and the fact that Amazon request and encourage forms and the use of its IPR procedure, we say it would be surprising, and we say it's just not likely that Amazon would think that someone using it would be threatening them. And we say that using the email correspondence that the judge did about third parties was to impermissibly shorn it from context. And but lady, I don't, if I
Well,
can.
there's one other point which you make in your skeleton argument, which you haven't made already, and that is about the timing of the 3rd of February email, because you say in your skeleton argument, well, that can't affect the interpretation of any of the complaints that preceded it. And you say in your skeleton, most of them did. And if you go through the chronology, a lot of them certainly did, and some of them came afterwards. So yeah, I take it you are maintaining that
I
point.
am maintaining that. I said it in my skeleton and,
Yeah.
and understood it. We say that that is right. One should not be looking at later if one takes the email into account. One should not be taking something sent later into account in construing an earlier document. So I do maintain that. Sorry, I didn't know if it
Would
needed.
you accept that if it's relevant to take it into account at all, and of course you say not, for the reasons you've given, then it could affect the interpretation of later communications?
I think that follows that it can, if I am wrong, that it is appropriate to take it into account in how the communications would be affected, then it takes it into account. It can't possibly do in my submission earlier, but it could do later. But obviously you have my submission that it's not relevant at all.
Yes.
Now, if I may just check, maybe.
Thank you very much. Yes, Mr. Cuddigan.
My lords, my lady, there is a danger in starting somewhat in media res. I'd like to begin at the beginning, and in this context that means the 1977 Act and the nature of a patent. We say that everything of utility about a patent stems from the powers given by the Act, in particular by the power to bring court proceedings and obtain relief in respect of infringement. And one can test that proposition in this way. Consider the value or utility of a patent which came with an irrevocable notice attached which said, "No relief at court." Such a patent would have no value or purpose whatsoever. You could wave it at competitors and they would ignore it with literal impunity. No one would want to buy it. It would be useless. It would be no different to a revoked patent. The reason it would have no value is that it is only the relief available at court which gives a patent any substance. And that relief is the cause of any change in behaviour of third parties. So when a patentee sends a letter saying, "I have a patent covering your product, remove it from sale," it's not coincidence that the demand reflects the relief available from court. It is implicit in the reference to a patent that the context for such a letter is section 60 of the Act, and the fact that a patentee can obtain an injunction and damages.
So are you saying that a request to remove a product from sale is of itself a veiled threat of infringement proceedings?
It is absolutely prima facie a threat. Now, there may be circumstances in which you could backpedal from that, but you cannot interpret a document asserting a patent detached from that relief, because that's all a patent is. So
Isn't that the same submission that you made unsuccessfully before the judge based on Zeno?
well, it's close to it, but I do have a respondent's notice in which I take it up again.
Right.
Can I take you to the legislation?
Yeah.
So this is Joint Authorities, tab 2. The relief that a patentee can obtain is in section 61, page 10 of the bundle. Section 61(1)(a), an injunction restraining apprehended infringement. B, an order for delivery up. So those are both preemptive relief. C, damages for infringement. D, an account of profits. Those are post-infringement financial remedies. And of course, whereas profits are an equitable remedy, damages are a legal remedy. They are available as of right whenever an act of infringement has occurred. So that's the relief that the court makes available. And if you turn back to section 60 on page 4, then this provides us the context for the availability of that relief in relation to the trade through Amazon, which we're concerned with, and in particular, who might be on the hook for this relief. Assume that the patent was valid and infringed. Well, the products in issue were manufactured by Carku in China. Carku then ships them themselves to the UK, and they are delivered to the third-party distributors' warehouses in the UK by Carku. The distributors then arrange for the products to be sold by Amazon. The Amazon website shows them as available, and consumers can order and pay for them. And sometimes Amazon makes those sales, sometimes they're made by distributors through the Amazon marketplace. Delivery is then typically arranged by Amazon. So if you look at section 60, we're dealing with a product. So we're in section 61(a). Carku would be infringing by importing these products, and both Amazon and the distributors are offering to dispose of these products through the Amazon website, and then disposing of them when customer orders are satisfied. So with a valid and infringed patent, NOCO is legally entitled to damages from Amazon and the distributors.
It might be worth just picking up the point that there is authority for the proposition that offer to dispose of goes wider than an offer for sale in the law of contract.
Yes. So it's a broad approach to offer for sale, and by posting these, but by showing these goods as available on the Amazon website, that is an offer for sale for which Amazon will be liable, and for which the third parties cooperating with Amazon to show the product available would also be liable. So that's the starting point. With your valid and infringed patent, you've got those legal rights from the Act. And that's critical context for interpreting these communications. Another part of the context relates to threats and third parties. And one of the key concerns about patent threats from the very outset, from their genesis, was the manner in which the spectre of litigation could be abusively deployed against customers or third-party distributors. And indeed, in Halcyon Brotherhood itself, the Lord Chief Justice, Lord Coleridge, addressed the difficulty caused by communications to persons who are going to deal with the plaintiff. It's page 63 of the authorities bundles for your notes. The problem arises, my lords, my lady, because customers or distributors will typically have a much lower commercial interest in the trade in issue than the manufacturer or importer. They may buy or sell one or two products and no more. And it's not worth their while litigating a patent in view of that low stake. And this was the concern highlighted by Mr. Justice Pumphrey in the Quad for Kids case. He quoted Lord Isher's well-known statement, "Better a man have anything happen to him except all his children die of the influenza than that he be involved in a patent action." That, of course, was indicative of the outsized demands of a patent action, and in particular the costs. And he went on to say it is entirely wrong for owners of intellectual property rights to attempt to assert them without litigation. The idea was that patentees should stand behind their assertions with litigation. And that's one we will return to.
That's the point that Mr. Justice Lightman picked up in the Johnson & Johnson case, where he referred to willing to wound but afraid to strike.
Absolutely, and it's one, my lord, which we will come back to in the context of the email that my learned friend ended with, the February email, which trumpeted NOCO's excellent habit of suing. And then Mr. Justice Pumphrey talked about threats to customers. He said, if somebody goes around saying, I will sue you for infringement of patent unless you stop buying goods from X, the natural response of anybody to whom that statement is made, stop buying the goods of X. The key point being that the threat is being made to X. And the distinction between, to X's customers, excuse me. The distinction between X and X's customers was itself picked up by the Banks Committee, which was set up to overhaul patent law in the UK. And we'll see how they characterised the position in the authorities bundle at tab 5. This is actually the Law Commission consultation paper from 2013, but there's a quote at page 55, paragraph 2.40, you'll see the Banks Committee was set up in 1967 to conduct a thorough reappraisal, and it noted that the aim of the threats provisions was to provide protection against the activities of a patentee who coerces the customers of a competitor into ceasing to purchase the competitor's goods without being prepared to put his patent to the test of court proceedings. So the customers are a key consideration here, and it is that concern which led to the amendment eventually to the 1977 Act in 2004, which excised from the threats provisions threats to primary dealers. It's okay to raise your claims with Carku if you're NOCO, but you shouldn't be sending letters to Amazon and third parties. Why does this matter? Because when you have in mind that the core purpose of the legislation is to prevent the coercion of customers, that helps you to identify a true threat. It is something of a tell if a patentee is aiming his communications exclusively at customers. And if we consider NOCO's notification practice, we can see that it involved a very deliberate campaign of customer coercion. NOCO sought at every turn to take advantage of this lesser interest of secondary dealers. And I can show you that from the core bundle, the chronology in the core bundle, tab 6. Page 67. You'll see towards the middle of the page, the first full entry, 20th of May 2020, Carku issued these proceedings. Carku claimed declarations of non-infringement and revocation of the patent in suit. 3 weeks later, on the 10th and 13th of June, this is 4 boxes up from the bottom, there was the 4th tranche of NOCO complaints to Amazon. Now, at that date, the patent is in issue in these proceedings. Infringement is also in issue in relation to products which are, so far as relevant to the patent, technically identical. NOCO have solicitors, Taylor Wessing, on the record in the UK. And yet, Taylor Wessing were not even instructed to write to Powell Gilbert about these products. The first my clients knew about these June notifications was when Carku's distributors told Carku that Amazon had told them that their products had been delisted. If NOCO had wanted urgent relief in relation to these 4th tranche products, they could and should have applied for an interim injunction at court. But they would have had to have satisfied the American cyanamide tests, and they would have had to have given a cross-undertaking in damages. We asked them to provide a cross-undertaking in damages against the de facto interim relief that they had obtained from Amazon. They refused. We relied on that refusal in bringing an application for an interim declaration of non-infringement so that our products could be relisted. The application was dismissed, and the judge relied on his view that we had a remedy in threats. My lords, my lady, NOCO well knew that they could avoid the inconvenience of cross-undertakings or having to satisfy the balance of convenience by making infringement notifications to Amazon instead. So that's what they did. NOCO was deliberately and systematically avoiding ventilating these issues with the primary dealer, Carku, at court, with all the associated checks and balances. That is customer coercion 101. And you can see they did it again. Core bundle, page 68. 2nd and 9th of July. Sorry?
It's low, page 67.
Sorry, it's back at the bottom of page 67. 2nd and 9th of July. Another tranche of complaints, 6 products complained of to Amazon. Again, the notifications were not made.
Sorry, where are you? July.
Sorry, I gave you a bad reference. So bottom of
Oh,
page
bottom
67.
Yes,
One up
yes,
from the
yes,
bottom.
yes, yes.
6 further products were subject to complaints. Again, the notifications were not made or mentioned at the time by Taylor Wessing. They were made to portray Amazon's delisting procedure as a form of ADR. They say it falls outside the threats legislation because this is Amazon helping people to avoid court. This chronology gives the lie to that submission, even though
Well, does it? I mean, the submission is that the policy has that effect.
Oh. Well, it's
not that some individuals choose to bypass it or don't do other things. because the submission concentrates on Amazon, although it ought to be concentrating on a reasonable recipient in the position of Amazon, but nonetheless, insofar as the policy is relevant.
Wholly contrary, use of this resource is wholly contrary to that submission, because it's not being used as an alternative, it's being used as an addition to obtain relief which they couldn't get from the court, notwithstanding that identical legal and factual issues are already before the court. My lords, my lady, there is much common ground in this appeal, and before turning to the grounds of appeal, I want to take stock in relation to it. It is common ground that NOCO asserted to Amazon that Carku's products fell within the scope of their patent, and that they used the word infringed in relation to those products. Of course, products cannot infringe a patent. It is legal persons carrying out prohibited acts which infringe. So an assertion of infringement is an assertion that someone has done infringing acts. It is common ground that Amazon has carried out acts set out in section 60 in relation to the Carku products. So if those products do fall within the scope of a valid claim, were delisted from Amazon as a result of NOCO's demands, and we don't understand it to be disputed that Carku suffered damage accordingly. And amongst all those undisputed considerations, NOCO says the correspondence in issue was not a threat for which Carku can be compensated. Could you please read the fifth ground in our respondent's notice, which is the core bundle, tab 2, page 22.
Yes.
The response is at page 63 of the bundle behind tab 5. So start at page the bottom of page 62, respondent's notice ground 3, and then paragraph 12 just recalls what it is. Paragraph 13 is the entirety of the response. Perhaps you could just read that.
Yeah.
So NOCO says that the argument assumes that the communications are unjustified threats of patent infringement proceedings. And that's it. That's the entirety of the response. The argument assumes no such thing. It only refers to the underlying policy. Our point is that, leaving aside the wording of the statute, the policy is unquestionably engaged. This is why the threats provisions were brought in response to Halcyon Brotherhood, precisely this sort of abusive behaviour. So even if the conduct is not within the terms of the statute, we say the policy is engaged. And we then rely on the detrimental consequences of NOCO's position being correct. And it is striking, we submit, that NOCO has no answer on the policy. They advance no challenge to the consequences we assert. And one might expect NOCO here to set out any beneficial consequences of their own position being right, but they've been unable to identify any. And that is, in a nutshell, why we characterise this as a somewhat dispiriting appeal. Seems to us the court is being invited to make the world a worse place and set the clock back to Halcyon Brotherhood, at least in relation to Amazon. which has an utterly dominant position in relation to these sorts of consumer electronic products. My lords, my lady, moving on then to ground one of the appeal, threats against Amazon themselves. We say the issue here is susceptible to a very simple three-step analysis, all of it factual common ground.
Can I just, before you go into this ground, I put to Mr. Nikodopoulos, why does it matter whether it's a threat against Amazon or a third-party distributor? His answer was, well, it might affect the scope of the inquiry.
Yeah.
So can I pose the same question to you? Why does it matter whether the threat is a threat to bring proceedings against Amazon or a third-party distributor?
I think the answer is it is unlikely to matter, but I certainly couldn't rule out the possibility of an argument based on causation and Amazon's response, which is different depending on whether Amazon is itself impugned or feels itself to be impugned, and whether
So it may be relevant to causation and hence to the scope of the inquiry.
Indeed.
Yeah.
Indeed. So a three-step analysis in relation to the communications to Amazon. Step one, Amazon choose to list and sell the 31 Carku products in issue. It must follow that listing and selling these products was their preferred course of action. And in that regard, Amazon promote themselves as offering a vast selection of products to customers. That's page 152 of the supplemental bundle. That is their USP. The Carku products are part of that vast selection, and without any interference, Amazon would continue to offer them. Step two, Amazon receive the takedown notifications from NOCO demanding the removal of these specific products. The issue on this appeal is the meaning of those notifications. Step three, in response, Amazon delists the products and stops selling them. Now, the specific acts of delisting occurred after the notifications were received. They are, however, relevant in a couple of ways. First, we say they are relevant to how a reasonable person would understand these notifications, because they're evidence of a response of a person who can be assumed, all other things being equal, to be responding reasonably. And as such, they are admissible within the somewhat tentative reasoning of Lord Neuberger at paragraph 19 of the Best Buy judgment. Do you want me to turn that up? He doesn't say much more than that, just the response to a notification. There's a supplemental bundle.
Authorities.
Sorry, excuse me, authorities bundle.
It was tab 13, I think, wasn't it?
Tab 13, I think it's paragraph 19.
Well, that's to do with subsequent correspondence. It's
Yes.
a matter of interpretation.
But what he says there is the October letter might be said to be admissible as it shows how the recipient of the September letter understood it.
I see.
And so we say, well, a fortiori, if you respond to the letter by delisting, it shows how it's been understood. But that's not the only way it comes in, because in any event, the fact that it is Amazon's practice to delist in response to a significant proportion of notifications is certainly part of the known circumstances. NOCO have themselves repeatedly relied upon it in support of their case, both written, it's paragraph 33, and in my learned friend's oral submissions today. So it must be part of Amazon's objective understanding that there is a very significant delisting response to these notifications.
But suppose Amazon's policy was to say, we do not delist until a court tells us to.
Yeah. So
Why would that alter the interpretation of the communication?
So this was a question that my lord asked my learned friend in a slightly different guise. I think the answer is this. If Amazon never did any delisting, if they just ignored the takedowns, that wouldn't be determinative of the question of whether it's a threat, because they might just be very sanguine about receiving threats. But because they often delist, more often than not, that does help you a bit. So no response, you'd say, well, I don't get anything from that. But if there is a very significant delisting response, we know that reflects an injunction at court. It's equivalent relief to an injunction at court. So that helps you understand how the communications have been understood, because they accede to most of the demands. So we say that the reasonable person in Amazon's position receives these notifications knowing that most of them result in delisting. And one of the most important questions for present purposes is, why do Amazon delist notified products? Because if the answer is to reduce their liability for patent infringement, I think my learned friend accepts that the appeal must be dismissed. Now, at trial, there were two candidates. NOCO said that Amazon were doing this to protect its customers from the horror of purchasing products that might infringe a patent. And we said Amazon was seeking to reduce their own legal exposure for patent infringement. Now, there can, of course, be multiple motivations for any course of action. And it is our submission that unless there is no significant element of legal self-preservation in Amazon's response, these notifications must have been received as threats of infringement proceedings. Now, on appeal, NOCO have changed course somewhat. The trial argument fell flat because retail customers don't care about patent infringement. And Amazon's own materials showed that it was concerned about counterfeiting and not patent infringement. Before this court, NOCO's argument is slightly different. They say Amazon wanted to appear tough on IP infringers, that they were promoting themselves as an alternative forum for IP dispute resolution. Neither of those points work either. There is no suggestion that Amazon makes any public statements when it delists a product. That, of course, is what they would do if they were delisting in order to appear tough. And we will see from the documents shortly that the Amazon procedure is simply a quick and dirty interim relief forum. It is subordinate at all times to the wider dispute, which it anticipates will be resolved at trial. My lords, my lady, if we turn to the judgment, core bundle, tab 7, page 118, we see that the judge substantially followed this stepwise approach in his paragraph, starting in his paragraph 250. He records the principal attributes of these notifications, and he rightly says that these are consistent with the notifications being classic threats. And then he considers whether there is anything to counter the assumption that these attributes justify. At paragraph 251, he considers NOCO's case on the Amazon IPR policy. And he says what he thinks that policy would need to demonstrate in order to support the case. My learned friend has overlooked the critical clause here. And that is, at the end of the first sentence, the judge says that NOCO would have to show that Amazon acts without regard to its own legal position. We say that is entirely correct and has been completely overlooked. NOCO have to show that when Amazon delists, when Amazon divert from their favoured course of action, which is to keep selling the broad array of products, that is not done in part to shore up Amazon's legal position. And the high point of NOCO's appeal is the Amazon IPR policy suggests they have other motivations. That is not enough. If you go to the grounds of appeal, behind tab 1 of the bundle, core bundle, page 17. Roman subparagraph 3 on page 17. In considering whether to delist, Amazon may have regard to its own legal position, as any company will. Go on, the judge was wrong to equate a regard to its own interests with an objective understanding that the communications were a threat of legal proceedings. We submit that that concession should be sufficient to determine the appeal. In that first sentence, NOCO accept that when Amazon decide to delist, that may be in part a result of consideration of their own legal position. Well, what is it about their own legal position that they might consider? The only right asserted was the patent. So the only aspect of their legal position that they could be considering is their liability for patent infringement. And that establishes a threat within the meaning of the Act.
Well, it doesn't, does it? The reaction to the communication does not establish a threat. At best, it is evidence of how a reasonable person might interpret the communication.
My lord is right. If a reasonable person reacted in the same way by considering their own liability for patent infringement, it's a threat. My lords, my lady, the judge held that the Amazon documentation did not help NOCO. In fact, the documents support our case. Let me explain why. You're going to need the supplemental bundle. I'm going to start with one document you have seen, which is behind tab 10, page 37. My learned friend read the passage in the middle of the page, which starts with upon receipt of a complaint and ends with submission of the complaint. And that is obviously concerned, that expresses Amazon's concern about legal liability to third parties whose products are going to be removed. But the message here is we, Amazon, don't want to be caught in the middle of someone else's fight. So you have to indemnify us if you're going to start throwing around infringement claims. That's the indemnity in the second paragraph. But the first paragraph says that we, Amazon, will hold tight to any defences we have against claims you might make against us. Again, that perceives liability as against the patentee.
Sorry, which paragraph are you referring to?
So, upon receipt of a complaint,
Yes.
we may take certain actions, including removal of an item. All such actions are taken without any admission as to liability. The reason it says that, my lady, is because Amazon don't want it to be said that by removing an item, they're conceding infringement.
Yes, of course.
And that is only consistent with the perception of an allegation that they would be liable, which of course they would. Now, in my learned friend's written skeleton, paragraph 37, it said that this is just Amazon making clear that they're not accepting liability. But that doesn't mean, and that doesn't mean that they view the IP notifications as threats. Well, we accept it doesn't conclusively prove that, but it does indicate that Amazon have their own liability well in mind in the context of these takedown notifications. So it is supportive of the case that Amazon are delisting products so as to limit their own liability for patent infringement.
These terms and conditions apply to everybody, I think,
Yes.
don't they?
Yes.
Are you going to deal with the heavy reliance that Mr. Lichodopoulos places on NOCO being a first party?
I am going to deal with it, but slightly mortified that only in precisely the way that my lord put it to my learned friend, which is that there's absolutely no reason to believe that anyone in the department who receives these notifications has any such knowledge.
Yeah.
Could you turn forward, please, to tab 23? This is a document you haven't seen. This is Amazon's utility patent neutral evaluation agreement, relied on at trial and relied on by my learned friends in paragraph 4 of their skeleton before this court, in support of the Amazon scheme is an alternative to court proceedings argument. Clause 3, waiver of claims. So what happens is that the participants in this are going to be the patentee and the distributors, the third-party distributors. Waiver of claims. Participants acknowledge and agree that neither Amazon nor the evaluator should be liable for any claims arising out of the procedure or evaluation, and participants hereby waive any claims against Amazon or evaluator. And then the last two sentences, participants agree not to sue Amazon or related parties for infringement of the patent with respect to the ASINs listed in Exhibit 1 or materially identical products. Nothing in this agreement shall limit a participant's ability to sue any seller or other third party for infringement of the patent. So the ASINs mean the Amazon products that have been named in the takedown notifications. I'll show you that in a moment.
I don't at the moment see how this goes anywhere. This requires both the seller or the patentee and the alleged infringer to sign up to this procedure.
Yes.
So it's a consensual procedure.
Yes.
I mean, if Amazon offered an arbitration service, that's nothing to do with these takedown notices.
Well, my lord, we say it is. This is a public document put out by Amazon, which is indicative of their attitude towards patent infringement on the site. Because what it says, we say it conclusively shows that Amazon are concerned about their own liability for patent infringement in relation to notified products. They go to the cost and trouble of arranging this service, and a condition of use is the waiver of infringement claims against Amazon.
But, I mean, the complaints form, to call it that, can be used for any sort of IPR infringement.
Yes.
So you could complain of trademark infringement.
Yes.
How would this patent evaluation bear on that?
It doesn't. But when you notify a patent, you do to Amazon, you do so in the context of this published document, which says this is an available neutral evaluation.
Yes,
so
well, I think that's what I'm putting to you. There is a different process available if you want to use it.
Well, right, but sorry, I'll come on to show that this is triggered by the notification. So you get a note, you have a notification, and then this process is available to you. And what this tells you in terms, we say, well, this is a term inserted by Amazon for their own benefit, and the existence of that term proves that Amazon perceive a corresponding threat of patent infringement proceedings from takedown notifications generally.
Yeah.
And this applies irrespective of whether the notifying party has a 1P or a 3P relationship. Now, in that last sentence, Amazon also acknowledges the existence of an infringement dispute between the rights holder and the third-party distributor is also at large. So that's relevant to our second head. Amazon is fully aware of all the infringement connotations associated with notifications. So what do Amazon know about a dispute that goes to neutral evaluation? Well, we can see that from the procedure, which is behind the next tab. And if you could start, please, on page 86, the fifth paragraph, which starts, the evaluation will address. The evaluation will address only accused products sold solely by third-party sellers on Amazon.com. The evaluator will consider whether a product likely infringes. The process is intended to evaluate the accused products in the listings on that date, and that the patent owner first alleged to Amazon that the listing contains infringing products. So the process starts with the original infringement notification to Amazon. And if you turn back then to page 85, the end of the first paragraph, Amazon, last sentence, Amazon will comply with the evaluator's decision pending any litigation or settlement between the patent owner and third-party sellers. And then page 88, could my lords and my lady please read to yourselves the final paragraph,
If any participant obtains a judgment.
please. That is, we say, entirely consistent with our position that any action by Amazon is in the shadow of and subordinate to court proceedings. This is an ADR procedure addressing interim relief on the Amazon marketplace, but the main event is still infringement proceedings at court. And that is what is threatened by the very same notifications. And this is all entirely consistent with what happened when Carku made a retaliatory notification against NOCO. And we say the facts in relation to that are generally indicative of Amazon's understanding and approach. And you've seen the letter a little earlier this morning behind tab 16. So this is at February 2020 from Amazon to NOCO. The first paragraph records the conventional procedure. It refers to NOCO products which have until recently been sold on our European stores. And then Carku has notified that the products are infringing on their patents. And following our internal policies, we have removed the products from our European stores. That repeated language is a direct link back to the allegations of infringement. The infringing act is the disposal through Amazon's European stores, so it has been stopped. Then they say they cannot typically take a view on the merits of third-party patent disputes. We say that means third parties is not Amazon. This isn't distinguishing. This is not an attempt to distinguish between 1P or 3P. Conventional use of third party, and you know that because it then goes on to talk about an arm's length indemnity and attaches a draft indemnity letter. So the idea that this is treating NOCO as somehow within the tent with Amazon is a nonsense. They can't take a view on the merits of third-party patent disputes. Why? Well, they're not primary dealers. It's not their fight. All these materials are consistent in that regard. And their position is, if you want a view on the merits, go to court. Then they carry on. We understand that in the opinion of NOCO, the products do not infringe the patents. So that's NOCO's position. Amazon won't take a position on the merits. What that means in substance is differing views as to who's going to win at court. And Amazon say they're prepared to relist the products, quote, while such disputes are still pending. i.e. before they're resolved at court. Before they're resolved at court, we'll relist them if you give us an indemnity. They want an indemnity in case Carku is right, because if Carku is right, Amazon is infringing. Now, they addressed that in the short term by delisting. Of course, that doesn't take account of liability for damages. But now they're saying if the product is going to be relisted, they want full legal protection. That is because they perceive a very significant threat of infringement proceedings from Carku's notification. Now, NOCO's only response is to say the court has no visibility as to what Carku said in its notifications. In other words, they say you don't know what the circumstances were that gave rise to this letter. We say it is unsatisfactory that NOCO have chosen to take that position. This is plainly a very difficult letter for NOCO. I suggested to the judge that if this indemnity request had been directed to Carku in response to the NOCO notifications, it would be determinative of the threats issue. And he agreed. Page 288 of the bundle of the transcript on page 528. But, my lords, my lady, NOCO were ordered to disclose known adverse documents by the 25th of June 2021. In the context of a threat claim, this is about as known and adverse as documents get. The deadline for fact evidence was the 8th of February 2022. This letter was not disclosed to us until a day or two before the PTR on the 16th of June 2022. And at the PTR itself, the judge indicated that the fact evidence was liable to be an unnecessary distraction, given all the other matters in dispute. So the parties agreed that there wouldn't be any cross-examination of fact witnesses. That was not a thread that was pulled on any harder in light of the judge's indication.
But wait a minute. The notification comes from your client to Amazon.
Yes.
The Amazon's response, as far as one can tell, is in the letter we are looking at.
Yes. So
It's by no means clear what else NOCO would have received in response to the threat, in response to the notification, which I infer was done online by Carku.
Right. So if this should have been disclosed to us by the 25th of June 2021.
Well, and then you'd have gone looking for what you'd actually said.
Then we'd have turned up with the pro forma, which would have been in exactly the same terms as any other.
Well, yes and no.
Likely to be in exactly the same terms.
Well, I don't know. That's the problem because of the additional information box.
Right.
I mean, you might simply have said, this is the product, this is the patent number, this is the product, and that's as far as we go. Or you might have said to Amazon, delist it now.
Right.
Or you might have said to Amazon, if you don't delist it, we'll sue you.
Right. My lord's entirely correct. But my point is this. The reason the answer wasn't before the court is that NOCO breached their disclosure obligations by about a year.
But what are we to do about that? I mean,
Well, so my submission, and it's part of my respondent's notice, is that given that that's the context in which this arises, the right thing to do is to consider this to be representative of Amazon's position generally in response to a neutral notification, a conventional takedown notification that says, we have a patent, this product infringes. And in that regard, we say it's entirely consistent with all the other materials before the court.
well, I mean, if I look at page 16 in the supplementary bundle, tab 3, that looks very much like a standard response to a notification.
Yes, so what you need to recall is that there was no claim from NOCO for threats against Carku. So the only matter in issue at trial
Yeah.
was NOCO's threats.
I follow.
So we didn't give any disclosure in relation to the retaliatory threat that we
No, no.
accepted.
But I think you were saying that we should regard page 56 as representative
Yes.
of Amazon's response to the submission of a claim on the online form,
Yes.
whereas 16 looks as though it's a typical response, and it doesn't
Sorry. Yes. No.
doesn't say the same thing.
I've not made myself clear. You're absolutely right. I'm not saying that's the sort of response everyone gets. What I'm saying is that the policy that one derives from that response should be taken as indicative of Amazon's attitude.
But you're not saying everybody gets a letter like this.
Absolutely not. That's not a pro forma response. That's a response when things have been escalated. But it does, we submit, tell you, gives you valuable information about Amazon's attitude. And in relation to that, we say Amazon is by default responding reasonably in asking for an indemnity in these circumstances. The only other point to make on ground one is the point my Lord's already raised about this 1p, 3p. In relation to that, my learned friend, who, to be fair to him, wasn't at the trial, slightly overstated the position in evidence. There was no evidence that Carku's distributors, there was no evidence as to the particular relationship with Amazon enjoyed by Carku's distributors, whether they were 1p or 3p. But importantly, Carku itself doesn't have any contractual relationship. Sorry. So yeah, I don't think there was any evidence that there was a contractual relationship of any sort with Carku, because Carku doesn't sell through the European Amazon marketplace at all. But the most important point is the point I've already mentioned, which is nowhere from the papers does one get an indication that those responding to this automatic notification, and there must be many such notifications coming in, have any knowledge of the particular status of NOCO.
Well, I wonder how far you can take that, because being Amazon, they can look it up on their system and find out. But perhaps the more relevant question is whether there's anything in Amazon's policy documents that suggests that notifications from 1p vendors get treated differently from 3p notifications from 3p vendors.
Indeed, I mean, I take both points, my lord. I wonder if that's a convenient moment.
Yes, by all means. 2 o'clock.